Adjourn.
I think the attorney is back there with this client.
We probably need him out here. Can you tell Mr. Evans we need him out, please? Did they give you the new indictment? The new indictment? So is it in the jacket? Baby, y'all handle it. Y'all handle it. What you want me to do? Can you get the finger out, please? Yeah.
Yes,
Yeah.
he's got it.
He needs to be a part of it.
Defendant is present in the courtroom, Your Honor.
All right. We have some pre-trial matters we need to check up.
I think there's some things we need to put on the record. First, this trial. And resolve numerous sort of issues and streamline things. One of the things, and we talked about this last week as we were picking the jury, is that the state would make an indictment or make modifications to the indictment so that the indictment was proper for trial, in that it gets rid of a couple counts that the state's not proceeding on at this trial, renumbers the counts so that we don't have count 1 and then count 4, but rather 1, 2, and 3. The 3 charges that would be on trial are conspiracy to commit first-degree murder, which is count 1 of this indictment, murder in the first degree, which is count 2 of the indictment, and convicted felon possession of a firearm, which is count 3 of the indictment. Counts 1 and 2 have not been altered, but count 3, the state and the defense have met, and we will have a stipulation during the trial that Mr. Johnson is a convicted felon. We're going to withhold from the jury the offense for which he was convicted. So instead, count 3 will read that he's been convicted of a felony offense that qualifies under TCA 3917 1307B1A. And it does not say the title of the offense, which is aggravated assault. Through this stipulation is consistent with case law. Mr. Evans and Mr. Johnson are going to sign that during the trial. So we have sanitized the indictment, I guess, is the proper terms for that.
Yes, sir.
And I think the court has a copy of the sanitized indictment.
Yeah, that. I do. Yes.
Very good.
And do you have the stipulation already typed?
We do. We have it typed, and Mr. Evans has reviewed it. I think he just needs to get his client to review it with him.
That's correct.
fine. And at some point, we'll make that an exhibit.
Yes, ma'am. The second thing, obviously there's cameras and media in the courtroom. There are also incredibly heightened security risk, security concerns during this trial, both inside this courtroom and outside this courtroom. This is one violent act from a series of violent acts that have occurred in this case or around this case. There's witnesses that have true security concerns. now and going forward after this trial. And there's also family members who have certain privacy rights and security concerns as well. I've been asked by several of the witnesses and by several of the family members, or maybe all of the family members, that I request from the court that the media not be allowed to film their faces during this trial or on their way in and out of the courtroom. This is a request that other judges in this building have granted numerous times when there's security implications like this, and that's what I would ask for, Your Honor. When they testify, it's customary in those circumstances that basically they film the feet of the witness, but obviously the audio and everything public. But I'd make that request with regard to several of these witnesses and all the family members coming in and out of the courtroom.
So let me make sure I'm clear about your request, that media not be allowed to film family members' faces or witnesses' faces, or both.
Yes and no. Not be able to film family member faces as they come in and out of this courtroom.
Okay.
But they not be allowed to film the two family members that will be the first two witnesses, their faces.
Okay.
And then going forward, maybe before we call a witness in which there's a particular security concern, we can address Your Honor as to whether or not they're able to film the faces of those particular witnesses.
Mr. Evans, any objection?
I have no objection to that, so long as the defense would be extended the same courtesy if there was a particular witness that we intended to call with that concern.
Certainly. All right.
The final thing we'll put on the
Well,
record
let me-
now. Oh,
Let me address before we go further. You want to step aside so I
I
can
did.
speak to Dean, my cameraman back there. Dean, so I'm going to grant the state's request that the family members, and whom you're going to know, because they'll probably be brought in very shortly together, that their faces not be filmed as they come in and out of court, okay? Or that their faces not be filmed. I'm going to, this is a security risk, this is a high security issue in trial that we're trying here this week. So for the safety of the families, I'm going to order that you not film their faces. The first two witnesses the state has informed me will be family members. The court has no problem with you filming chest down, feet, but not their faces. You understand?
I understand.
Any questions?
Yes.
Yes.
As long as we can do our due diligence. I mean, actually, because I know nothing of this case, I know nothing of anything here. I'm from out of state.
Yes, sir.
So I want to make sure that I do what you tell me. So I have
So-
no problem to say.
The public information person, Ms. Whitaker, will let you know.
Okay.
This is gonna be her job for right now.
Okay.
So let you know when family members are coming in, for you not to film those faces. And I'm telling you now, the first two witnesses, you won't be filming their faces.
Gotcha.
All right? From that point, then the state's going to let you know, or let me know to let you know, whom, or the defense about with faces that don't need to be shown.
Thank
Okay?
you.
Can we move her down there?
She got a job. All right, what's the third one?
Just go ahead and tender to the court so Your Honor can go ahead and sign it. There's a stipulation with regard to the first witness, the corpus witness,
Yes, sir.
that Mr. Evans and I have already signed and got tendered to you.
So let me make sure I understand this. So the corpus witness will be testifying, but won't be showing photos.
The corpus will be testifying, but will not show any autopsy photos of the corpus witness.
So This is a stipulation of fact. I shall read it into the record right now. You have an objection to that?
No objection.
The parties in this matter, the state of Tennessee, represented by Paul Hagerman and Iris Williams, and the defendant, Justin Johnson, represented by Luke Evans, respectfully have agreed to the following. The victim in this case is Adolph Thornton Jr. He was a living person who is now deceased. Adolph Thornton Jr. was, as you will hear in later testimony, the same person that autopsy 2021-2619 was performed upon. These are facts agreed to by the parties and may be accepted as true without the need for a witness or further proof. This is a stipulation made in all homicide cases so that family members of the victim do not have to view autopsy pictures of the victim. It's so stipulated and approved by the court.
I'll grab that from your clerk.
Right, let her.
First
I'll let-
witness. And then the final
And at some point,
thing,
you can read that to the jury.
yes ma'am, we'll do it with the corpus witness, who will be our first witness.
Okay.
So Ms. Williams can get that from your clerk here in a second. The final thing, this is, Mr. Evans and I have both worked hard and had numerous meetings with each other in an attempt to sort of go ahead and address and with regard to pre-trial, many of pre-trial sort of matters. So let me put one thing on the record to sort of allay any concerns Mr. Evans may have, but also give the court the heads up. And it may be that with a couple of these witnesses, before they actually testify, we may need to have the jury out so your honor can admonish the witnesses with regard to one thing. There are other acts of violence. I think I mentioned other acts of violence that are related to this case. That at least two of the prospective witnesses are aware of, were present for, and these are acts of violence in which Mr. Johnson also personally engaged. Whether or not those are relevant to this case, it's the state's intention not to put on evidence or elicit testimony with regard to these other acts in this trial. And that's something Mr. Evans and I have talked about sort of at length, and we've come to sort of that understanding with each other. And so before that particular witness testifies, I think it'd be smart to have the jury out and just instruct the witness again that we're not going to talk about those other crimes. Obviously, that's for our case in chief and for direct. Where cross-examination goes or whatever is, a different story. But I want to lay any concerns. I won't be talking about other crimes or other acts of violence in my opening or anything like that. Our plan is to proceed, on this act.
Anything else to add to that, Mr. Evans?
So the only thing I would add, Your Honor, is obviously Mr. Johnson in no way concedes that he committed any of the other acts, but other than that, what Mr. Hagerman has said is accurate, and we've met and had an understanding about that.
Thank you. We probably need to make that stipulation an exhibit.
We can,
You want to do that now, or you want to wait?
Well, we can do it with a witness on the stand, Judge, if Your Honor wants to.
That's fine. Anything else?
Judge, I just have one issue to bring to the court's attention. When we were doing jury selection, I made a motion to allow Mr. Johnson to sit at counsel table based on his right to a fair trial and to assistance of counsel. Your Honor denied that motion initially. I'm renewing that same motion today so that he be allowed to sit at counsel table and assist us during the trial. And one case in point is, as Your Honor remembers, one of the jurors that we voir dire gave his impressions, and we voir dire on it somewhat, about getting the sense that somebody wasn't engaged with the lawyers, that would give him a sense that they didn't really care about their case. Although other jurors didn't state that on the record, that is the concern for prejudice of Mr. Johnson and his right to a fair trial. Also, his ability to converse with us, be at table, be able to view things without us having to turn around when the trial's going on. is paramount to him being able to fully exercise his right to counsel.
During jury selection, I specifically remember you asking a particular juror, was her thoughts about the defendant and what he may or may have not done in the past affected by the fact that he wasn't sitting at counsel table. And she specifically said no, that didn't have anything to do with why she felt the way she felt. That juror was stricken, but you had the ability at that time, as you needed, to ask how people thought about that. So I'm going to continue to deny that request.
Thank you, Your Honor.
And before we get started, juror number 4 was a no-show, and so she has been excused. That's enough. Anything else? We will move. Okay, there's move chair. Anything else we need to take up before we bring the jury in?
No, Your Honor.
Mr. Hagerman, you want to bring the family in before the jury comes in? You want to bring the family in?
Yes, yes, Your Honor.
You see them, but they. This is how they proceeded.
Let me see what they do.
I'm staying. I'm missing.
Okay.
Put the phone down. Put it down. Boy, Hopkins. Put it down in the pocket.
We ready? Catherine, do a microphone. Welcome, Lou. I'm sorry. Move it. I didn't know if you picked down there. Friday. Check. So, I forgot we were gonna have still cameras in the back. They need to know the same thing about taking pictures, right? Photographers, we're not taking facial photos of any member of the family. We're also not taking facial photos of the first two witnesses, okay? Feet, chest down, but no facial photos. There may be more witnesses to come that you'll have to do the same thing for, but we'll let you know as they come. that is?
Ray Young,
Yes.
right? Jury's not getting into the court.
You can remain standing. You raise your right hand, please. When I finish, you can just all say, "I will." Do you solemnly swear or affirm to well and truly try the issues that traverse herein, joined between the state of Tennessee and the defendant, Justin Johnson, upon a true bill of indictment, charging him with the offenses of conspiracy to commit first-degree murder, murder in the first degree, and convicted felon in possession of a firearm, a true deliverance make, and a true verdict render, according to the law and evidence, so help you God?
I will.
Thank you. You may be seated. Good morning.
Good morning.
Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you are to go about reaching your decision. But now I simply want to explain how the trial will proceed. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant has pled not guilty to all the charges. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorney's arguments, and instructions of law, the trial jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, the defense may make an opening statement if he so chooses. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions, I will excuse the alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at your verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, a defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each witness's testimony. In making up your mind and reaching a verdict, do not base any decision on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. Some of you have probably heard the terms circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. Keep in mind that you may consider both kinds of evidence, which are considered to be of equal value in the law. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. During the course of the trial, you should not talk with any witness, defendant, or an attorney involved in this case. Please do not talk with them about any subject matter whatsoever. You may see them in the hallway, on an elevator, or at some other location. If you do, perhaps the best standing rule is to not say anything. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. I do not know if there will be any media reports in the newspaper, on television, on the radio about this case. You are not permitted to read, watch, or listen to any reports. You as jurors must base your decisions solely on the evidence you hear in the courtroom. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness may give. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular response that was made or statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. You may not ask questions. It is the responsibility of the attorneys to present the evidence. You must decide the case on the evidence presented to you. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. We will try to resolve some of these things in the morning before we get started. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for us all. If after your deliberations, you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you. We will now proceed with the reading of the indictment.
Indictment 22-04769, State of Tennessee versus Justin Johnson. It's an indictment in 3 counts. Count 1 is conspiracy to commit first-degree murder. Count 2 is murder first degree. And count 3 is convicted felon in possession of a firearm. This is count 1 of the indictment. State of Tennessee Criminal Court of Shelby County, September term of 2022, count 1. The grand jurors of the state of Tennessee duly selected, impaneled, sworn, and charged to inquire for the body of the county of Shelby, Tennessee, upon their oath present that Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, and Jermarcus Johnson, between June the 1st of 2021 and March the 1st of 2022 in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully, intentionally, with premeditation, and with the intent to commit the offense of first-degree murder as classified in Tennessee Code Annotated 3913-202 against the person of Adolph Thornton, Jr., enter into an agreement with each other to commit the said offense. The said Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, and Jermarcus Johnson, acting for the purpose of promoting or facilitating the commission of the said offense, and agreeing that one or more of them will engage in conduct that constitutes the said offense. In furtherance of said conspiracy, one or more of the parties to the conspiracy committed an overt act, to wit, Justin Johnson, Straight traveled to 2370 Airways Boulevard and killed Adolph Thornton Jr. Cornelius Smith traveled to 2370 Airways Boulevard and killed Adolph Thornton Jr. Hernandez Govan solicited both Justin Johnson, also known as Straight Drop, and Cornelius Smith to kill Adolph Thornton Jr. Jamarcus Johnson aided in Justin Johnson, also known as Straight Drop's, hideout and escape after the killing of Adolph Thornton Jr. Aided communication between Justin Johnson, also known as Straight Drop, and Cornelius Smith after the killing of Adolph Thornton Jr. and facilitated payments to Cornelius Smith for the killing of Adolph Thornton Jr. All of which is in violation of Tennessee Code Annotated 3912-103 against the peace and dignity of the state of Tennessee, signed by the District Attorney General for the 30th Judicial District. Count 2, State of Tennessee, Criminal Court, Shelby County, September term 2022. The grand jurors of the state of Tennessee, duly selected, impaneled, sworn, and charged to inquire for the body of the county of Shelby, Tennessee. Upon their oath, present that Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, on November 17, 2021, in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully, intentionally, and with premeditation kill Adolph Thornton Jr. in violation of Tennessee Code Annotated 3913-202 against the peace and dignity of the state of Tennessee, again signed by the District Attorney General for the 30th Judicial District. Count 3, State of Tennessee, Criminal Court of Shelby County, September term 2022. The grand jurors of the state of Tennessee, duly selected, impaneled, sworn, and charged to inquire for the body of the county of Shelby, Tennessee, upon their oath, presented Justin Johnson, also known as Straight Drop, on November 17, 2021, in Shelby County, Tennessee, and before the filing of this indictment, did unlawfully and knowingly possess a firearm, having been convicted of a felony offense that qualifies under Tennessee Code Annotated 3917-1307B1A on May the 2nd, 2017, in Division 8 of the Criminal Court of Shelby County, Tennessee, under docket number W1700355, in violation of Tennessee Code Annotated 3917-1307 against the peace and dignity of the state of Tennessee. Going in reverse order, that third count was convicted felon in possession of a firearm. That second count was murder in the first degree. And that first count, the long one, was conspiracy to commit murder in the first degree. It's signed by the foreperson of the grand jury, a true bill having been returned on November the 10th of 2022.
Mr. Justin Johnson, how do you plead?
Mr. Johnson pleads not guilty, Your Honor.
Thank you. Okay.
And welcome to Memphis. Two things first. I told you last week, there's going to be cameras, there's going to be TV cameras, you hear them clicking, you know right now. When you stood up to take the oath, you probably heard them clicking too. But like we told you last week, and what the judge has instructed each and every one of them, is they cannot film y'all at all. When those cameras were clicking when you stood up to take the oath, they were taking pictures of the judge. As I'm talking to you now, they're taking pictures of me, but not y'all at all. Not at all. Second thing, like I told you last week, we don't have the big windows looking out into the city. We don't have the fancy wood benches in the back. Our room is a third of the size of what we were in last week. That wood behind you is probably not even wood. We got a lot of carpet. We got a lot of carpet. But in Memphis talk, we still call this a courtroom. And in this courtroom, the words we talked about last week, presumption of innocence, elements, cases, charges, criminal responsibility, they're not just words. They're the law, and we take an oath to take them seriously and to follow them, even without the fancy wood benches or the big windows. We call this a courtroom. And in here, our job is to apply the law to the facts and to do what's right. Welcome to Memphis. Welcome to Memphis, November the 17th of 2021, in the middle of the afternoon, just after noon, about 12:20, 12:21, 2, 3, 4, in the afternoon. We'll start. You can stop there. Can everybody see it?
Yes, sir.
This is Memphis, Tennessee. This neighborhood is close to the airport. It's called Orange Mound. It is a historic neighborhood in Memphis. One of the first predominantly black neighborhoods that had so much history, so much art and culture, and of such, significance, that it used to be compared to Harlem in New York City. There was a time when it was particularly vibrant, had a theater, arts. It's an important neighborhood in Memphis. It is less than 15 minutes from this building. Like I said, it's by the airport. In the 80s and 90s, it became riddled with crime, with drugs, with poverty, with gangs. It is trying hard nowadays to make a resurgence, to go back to what it was. There are families that have lived there for decades, generations. There are businesses and other things that have been there for decades. What we're looking at here is one of those Memphis businesses, a family business. This is the storefront of Makita's Cookies. This is the front of the store. This is its parking lot in front of it. Makita's Cookies. They sell butter cookies, basically. Some have icing on them. This is simple butter cookie. People say they're real good. In Memphis, they say they're fire. So we got a cookie store that sells fire butter cookies in the middle of the day at 12:21 in the afternoon.
Mr. Hagerman, you're standing in front of them.
Thank you, Judge. You can stop it here, Iris. All right, so in 2021, people thought that was like a Lamborghini or something, because they hadn't seen the new Corvettes yet, really. They weren't around. That is, in fact, one of those new Corvettes. It has a special wrap on it, is what they call that. It's not something you can buy, from the dealership. You have to get that done yourself. Well, here that's a special rap that the Memphis rapper, artist, Young Dolph, had on several of his vehicles. There's a couple times in this video we'll just have to wait, but it's a matter of seconds, and it's the last seconds of his life, so we can wait for him. You'll stop there first. All right. This taller man here in the yellow shirt, blue jeans, white shoes. His name is Adolph Thornton, Jr. You've heard me read it a couple times now. He grew up in Memphis. The neighborhood he grew up in was Castalia, not terribly far from this, also a neighborhood in South Memphis. You'll see a member of his family testify this week, and she'll tell you a little bit about his background and his family. I'll tell you a little bit about him right now, though. He is an ambitious young man who is a rapper, Memphis rapper, who rapped about the things that he saw growing up and that he sees in his neighborhood in Memphis. Some of that is drugs, some of that is violence, some of that is crime, some of that is gangs. Whether or not we agree or disagree as to whether or not that subject matter, are things we should be listening to or not, I can assure you it's real. You rapped about stuff that is real. You rapped about stuff that was real. And one of the things that meant everything to him in terms of what is real is he wanted to make it for himself. He wanted to make it for himself. He wasn't interested. He wasn't interested in joining others. He wasn't interested in being promoted by other people. He was all about making it himself. He felt like when he grew up, he called it his come up. That's what he called it, his come up. That it was rough and hard, but it was important that he got through it himself, and he wanted to make it for himself. And he made it for himself as a rapper, as an artist. Young Dolph became famous, shortened to Dolph. Very famous. Wanted to make it by himself. Wanted to be self-made, but it wasn't just about him. Because he also wanted a record label. He wanted to promote other artists. He wanted to make them famous. And so he started not just his own rap career, but a record label that's called Paper Route Empire. Paper Route. Like a young man or woman would have to make money on the side throwing papers. But also a play on the word paper. Because in Memphis, slang for money is paper. It's sometimes abbreviated PRE, Paper Route Empire. And that is Dolph and the rappers that he promoted. Trying to make it on your own is obviously hard. in this game, trying to make it on your own can create enemies. PRE, Paper Route Empire, his label, is not the only label in Memphis. He's not the only famous rapper in Memphis. Another label, CMG, Cocaine Music Group. And they became an enemy. They wanted Dolph under their label, but he turned down millions. I want to do it myself. The second time, they wanted Dolph under their label, but he turned down many millions. I want to do it myself. And in this game, whether it's smart or not, there are things called, just in Memphis, we call them diss tracks, DISS. A rap where I may insult, level whatever sort of insults and everything else I want to in the song itself. And Dolph had plenty of those. And he had plenty of those directed at this other label, the Cocaine Music Group, at their artist, and at their number 2 person. His name is Big Joke, the number 2 person of Cocaine Music Group. Through the years, and I'm talking years before what we're going to watch, having nothing to do with Mr. Johnson on trial, there were highly publicized incidents of violence directed by CMG against Dolph. He even wrote songs about it. Bulletproof. 100 rounds. And he also spewed out the disses and the insults. Stop it there. This man here got out of the car with Dolph. That's his brother. His name's Marcus Thornton. His brother, his friend. This thing that we're about to watch has had a terrible impact on Marcus. Not just his brother and his friend, but he also works security for them. In fact, as Marcus walks in this cookie store, he has a gun on his person, and he has another gun in the car. Dolph was well aware of the threats and the violence from CMG that were constantly hanging over him and his people. We'll wait 30 seconds. side of there. That car that just drove up came from this side of the parking lot. It had actually been following Dolph on the street. When Dolph turned in, it went up to this light where it got stopped for a few seconds and then came around. It's a white Mercedes. There's other pictures where you'll be able to see it more clearly, but it's a white Mercedes with back end damage back here on the back passenger side of the car. It's a stolen car. It's a stolen car that our defendant here, Justin Johnson, traded for one car for another at a gas station about 10 hours before this murder happened. This man got out of the passenger side of the white Mercedes. Door's still open. We saw him run to the parking lot. He's here with a large semi-automatic weapon. He's in a hoodie, he's got sweatpants, and he's got white shoes. We'll see a second man come out of the car too. Those two men that we're going to see come out of the car, they're going to gun Dolph down. He's inside the business. He has walked over to sort of where the bathrooms are in the business. He's as close as I am to y'all. There's the window, and he's getting shot through the window. Both of these men will shoot. This one in particular, it looks like he's never shot this type of gun before. It's because he probably hadn't. The second man out of the car who's driving is our defendant, Justin Johnson. Neither one of these men are professional hitmen. If it looks like they don't take tactical shooting stances, it's because they don't. Let's watch Mr. Johnson get out of the car. Let me stop it here. This is Dolph here. Remember, he was wearing the yellow. This is Marcus. Remember, I told you he had a gun. He tries to return fire as these two men quickly shoot Dolph. Dolph's body's riddled with bullets. He shot all in the back, in the face, in the neck, in his arms. The first man out was Cornelius Smith, and he has that semi-automatic weapon shooting wildly into Dolph. The second man out was Justin Johnson, who has a handgun, who's firing at Dolph as he lays on the ground. Marcus Thornton starts firing back once he hears the shots. Now we see him emerge from the building. Can't tell in the video, but Marcus actually hits Cornelius in the shoulder, shooting back. I want to spend some time with two things. This Mercedes, these two people, Justin and Cornelius, they didn't fall out of the sky on a Wednesday at 12:20 in the afternoon at a cookie store. They had been looking, they had followed them, and for them, this is just business. This was just business. They don't even know each other that well. Let's start with Cornelius. Cornelius is from this neighborhood, Orange Mound. He's in his early 30s now. Cornelius has had serious drug problem. He does ecstasy and Percocet. He gets his drugs over on Bradley Street, just over 2 miles from the scene, from a man whose name you have heard, Hernandez Gobe. They don't call him that, though. They call him Quet. His middle name is Marquette, and it's shortened to Quet. So Cornelius gets his drugs from Quet. Quet is what in Memphis we call an old head, older guy, lives in the neighborhood, lifelong criminal, in and out of jail through the years. Quet sells drugs. Quet gambles on sports like crazy, online sports stuff. And then Quet tries to identify young rappers and tries to shop them to CMG, hoping to get a cut, hoping to hit it big. Years ago, he and his brother missed out on one of those big rappers. But Quet knew a young rapper who he was in the process of shopping to CMG. And that young rapper is Justin Johnson, who goes by Straight Drop. Sometimes I just call him Drop. So Quet's the common person. He knows Cornelius from the neighborhood, knows him well, sells him drugs. He knows Justin Johnson. He's trying to get him to be the next CMG rapper. But not just that. The business is not just rap. Because Big Chook, person I told you about before, that number 2 guy at CMG, he's put out a hit. A hit. $100,000 to whoever kills Dolph. He has met with Justin. He has met with Cornelius. And they think they're ready to do it. They're definitely willing to do it. For Cornelius, it would be 50 grand, I guess, that he could waste away on Percocets and ecstasy. For Justin, it's 50 grand, but also a chance to make it big with CMG. To become the next famous Memphis rapper. Straight Drop. They were sent here. They were sent here. But not professional hitmen. Not even monsters. I'm not going to call anybody a monster. This is just business for these two. Money for Cornelius, money and rap fame for Justin Johnson. They did the best they could, really. Stolen car. Better to use a stolen car that can't be traced back to me. When we still shot the video, you'll see that they're wearing gloves. Afterwards, the guns get disappeared. The car gets ditched in a neighborhood and wiped down and moved and wiped down and moved. Their plan is to go their separate ways and just disappear into Memphis. They did the best they could. I guess I could have gotten away with it. If you get the guns gone, if you get the car wiped down, get the car hidden for long enough, you're wearing masks, you're wearing hoodies, you're wearing gloves. Do it so quick, but it takes seconds. You get in, you get out, you get separate, you get disappear, and I guess you get away with it. There's a problem there, though. There's a problem there. Still staring at us. One of the big problems. It's not 1981. It's not 1991. It's not even 2001 when I started in this building. It's 2021. It's 2021. And what I started talking to you about when I first stood up, what you didn't think about, what we don't think about, almost ever anymore. These places have cameras. Places have cameras. It's the hotel lobby. It's walking into the building. It's this courtroom now. A lot of places that have cameras. And also what we don't think about, we didn't have to in 1981 or 91, whatever, is we carry phones around. Phones that can give people clues as to where we were, what was going on. We can wipe down cars. We can use stolen cars. We can get rid of guns. We can disappear in the neighborhoods. We can separate from each other. But it's 2021. And I guess I didn't think about that. We back up the video about 3 or 4 seconds. All right, we can stop there. All right, so what we saw before was this man first. Remember the one with the automatic weapon, the larger of the 2 weapons? He got out of the car first from the passenger side. He ran around and shot the gun wildly into Dolph. We're concerned in this trial. Now, Mr. Smith is charged with murder too. So is Mr. Govan. Then we've heard that Jamarcus is charged with conspiracy, but in this trial, this is Justin Johnson's trial. This is Justin Johnson. He is wearing tennis shoes that have white soles. See this one better in this shot. White soles, they're black with a little white stripe. There are times in the video where you can see his socks, and they're white socks. He's wearing gray sweatpants. In fact, there's angles of the video that you can see that this gray sweatpant on this left leg has a little silver-like emblem on it, real small, it's shiny sometimes. He's wearing gloves. See it maybe better there. He's wearing a black hoodie. He's wearing a mask. And he's wearing a Bass Pro hat. All right, so black tennis shoes, the white sole, white stripe up the middle of the tennis shoes, white socks, gray sweatpants. There is a little emblem that you can see in some angles on the leg. Black hoodie. Here during the shooting, he's wearing a mask, and he's got a Bass Pro hat. Bass Pro stores only man, not even a quarter of a mile from where we're sitting, right here. There's other angles and other still shots where you can clearly see it's a Bass Pro hat. And there's other angles where you can see the little emblem that it has on his sweatpants. Call on video here. There's a building in Memphis. This happens in the historic neighborhood itself, Orange Mountain. But there's a building in Memphis, it's a historic building. There's only like 10 or 12 of these buildings in the whole United States. They used to be, back 7 years ago, Sears buildings, okay? Huge. Largest square foot building in Memphis for many, many years. At the time, Sears was sort of like Amazon before Amazon existed. Because these big warehouse buildings and everything, you come and place your orders, and they stayed. It was quite sort of an amazing thing. The need for those buildings went away. In Memphis, the building was abandoned for decades. They have pictures of it, abandoned. And it's crazy because it is the largest square foot building in Memphis, and it was abandoned. In other cities, there were 10 or 12 of these things. Some were abandoned, some were actually even torn down. But a few were repurposed. And in Memphis, over the last 15 years, ours was repurposed and renovated and redone. Amazing building now. It has a high school in it. It has restaurants in it. It has businesses in it. Has a YMCA in it. Has a brewery in it. Has all sorts of things in it. Also has apartments in it. Has 4 floors of apartments. So when you live here, it is a nice place to live. You live sort of like in a shopping mall with your restaurants and everything else right there. Okay? Justin Johnson, 2021, has a mother and a sister that have apartments in that building. The building is 12 stories high. Huge footprint. November 17th, 2021. This is less than an hour before the killing. This is Justin Johnson in the elevator, leaving the building about an hour, really less than an hour, before the killing. Black tennis shoes, white soles, white stripe up the middle, gray sweatpants, black hoodie, Bass Pro hat. In fact, you'll see picture after picture and video after video. It's the same outfit he was wearing the night before. We'll see him in this outfit from 2 o'clock in the morning, same day, all the way up to leaving the building right before the killing. The exact same outfit as that man on the video. A guess as to what kind of car he got caught leaving in at the parking garage of this building. A white Mercedes with back end damage, just like the one we seen in the video, less than an hour before. You can get rid of guns. You can white down cars, can disappear in neighborhoods, but it's not 1981, it's 2021. And from 2 o'clock that morning to 12:23 the same day, he is caught again and again. And it's not just before the murder. Cornelius got shot. Can't tell the video. He got shot in the shoulder. He needs medical attention, or at least needs somebody to look at it. You'll see the text messages. You'll see the phone location type stuff. You'll see that Mr. Johnson and Mr. Smith, after they ditch the car in the neighborhood, they have another car waiting. That they go over to Mr. Johnson's cousin's apartment. An apartment complex that used to be called the Two-Lane Apartments here. Now it's called the Gospel Gardens Apartments. We're talking within 45 minutes of the killing. So we have the killing. Cornelius gets shot, ditch the car, get in Johnson's other car. Then we go to Johnson's cousin's apartment, 2 lanes. So they can try to bandage up Cornelius. So Johnson can change his clothes. So they can try to get away and disappear. How do we know that? Well, their phones, but not just their phones, because again, it's not 1981. That apartment complex has video. You see them arrive in Johnson's other car, which is a white Expedition. You see them from distance walking into the apartment complex. You see Johnson's cousin directing them where to go. You see at this point Cornelius has his shirt pulled up weirdly because he's been shot in the shoulder. You see Johnson wearing the same clothes. The gray sweatpants, the black shoes, the black hoodie, the Bass Pro hat. You see him go inside the apartment. At some point you see Johnson come out. Someone else has brought him a change of clothes. You see Johnson get inside that car, inside the back seat of his friend's car, and change his clothes. No longer in the murder outfit. And you see them leave. To disappear almost. Because later that night, we see Johnson back at that big building called Crosstown. He's in his new clothes that his friend brought him at the apartment complex. And he goes to his apartment, and he packs up, and you'll see him at the elevator with his suitcase and everything else, ready to get the heck out of town. The contract hit a big joke. The hitman found and solicited Hernandez Gomez, who they call Clay. The hitman, a druggie from the neighborhood, Cornelius, and an aspiring young rapper, Straight Drop. And they could have gotten away with it, but they didn't. What we watch up here is so quick. And we watch it and we call it violence. That's a man with a family and with a life who's laying at the edge there in the yellow, riddled with bullets, dead. We watch that and we call it violence. For Cornelius Smith and for Justin Johnson, it was just business. They call it business. What we do here this week, in here, we'll see the video plenty of times. We'll see the crosstown videos, the apartment videos, we still still shots and everything else. What we do here this week together is not violence and it is not business, it's justice. And at the end of this, you will see that both Cornelius Smith and Justin Johnson are caught. And they're both guilty of murder. They're both guilty of conspiracy to commit murder. And Johnson, as he is a prior felon, is also guilty of convicted felon in possession of a handgun. And if being caught on video is not enough for you, you'll also hear it from Cornelius Smith's mouth. That's me with the assault rifle killing Dolph. And that's Justin with the handgun with me killing Dolph. Even he realizes he's just caught.
Bill?
Thank you, Judge. Good morning. Good to see you again. Thank y'all for being here. It's an important day. It's going to be an important week. As you all sit in judgment and you evaluate the evidence in this case. And as we talked about in voir dire, Mr. Johnson sits before you innocent. And he'll remain that way. Because at the conclusion of this case, once you've viewed all the evidence and heard all the testimony, you will not be convinced beyond a reasonable doubt that he did this. Because he didn't. Now, Mr. Haggard was a very skilled attorney, did a great opening statement. But there's always two sides. And there are certain things about this case that I'm going to urge you to be paying particular attention to. You heard a little bit about Govan, and I anticipate you'll get to hear from Govan in this case. You already heard you're going to be hearing from Mr. Smith. You know, and Mr. Hagerman talked about Mr. Govan and said he liked to, you know, get an interest in young rappers, right? He liked to exploit. He liked to exploit young rappers. Like Mr. Johnson. He brings no skill to the table, but you're going to hear testimony about how he intended. It was his sole mission to get a 30 to 60% piece of Mr. Johnson. You're going to hear him say, oh man, Mr. Johnson was going to go platinum. And he and his god brother had missed out on this golden opportunity for another rapper, and they weren't going to let that go by. They weren't going to let that go by again. And so he gets his claws into Mr. Johnson. All right? And what you're going to hear is, as the process goes on, is the idea is that he's going to sign with CMG, Mr. Johnson is. But there comes a point in the road where what Mr. Govan wants, which is a meal ticket, the payday, and what Mr. Johnson wants, differ. And you're going to hear about how they take this trip to Atlanta. And the whole idea is that they're going to go to Atlanta, and this is Mr. Govan's chance. He's got another guy he's going to bring in to help sell the management contract, which is going to get him this massive piece of this young up-and-coming artist. And you're going to hear, this is about September of 21. This is right before November. And you're going to hear that they go to Atlanta to meet Jook, who is one of the higher-ups at CMG. Right? They go to Atlanta, and while in Atlanta, Mr. Johnson decides, I'm not going to go your way. I'm not going to go your way, Govan. I'm not going into business with you. I'm going to do it without you. And at that moment, I anticipate you're going to hear Mr. Govan say he was really mad. He felt some kind of way about the fact that he had, in his mind, his perception was he had done all this to help this up-and-coming star, and now he was going to be left to the wayside, and he wasn't going to get a piece. And he's so angry that he leaves Mr. Johnson in Atlanta. Leaves him there. Mr. Johnson has to find another way home. You know, Mr. Hagerman talked about, it's not 1981, right? It's 2024 now. It's 21 when this happened. But there are certain things that are as old as time. And that's greed, right? Pride, and deceit. And that's what Mr. Govan has, is greed. And then he gets angry because if he can't get a piece of this young artist, nobody can. Nobody can. It's time to tank this one, because he's not going to go with Govan. And Govan, you're going to hear, and the state has said, is soliciting. He's in the middle of this thing with Dolph. It's going to be important for you through this case to really pay attention to credibility. When you hear witnesses like Govan testify, why is he saying what he's saying? What's he getting at? He's getting something, and you're going to hear it. He's got a vested interest in making sure that he saves his own hide and takes this young rapper, this young man, off the board, since he wasn't going to go with him in the first place, since he abandoned him and decided not to share any of his money going forward. The same is to be said for Mr. Smith. You're going to hear from Mr. Smith. And Mr. Hagerman tells you, he says he's going to tell you that was me and Justin. You will also hear about other things Mr. Smith has said during the same time that he's been meeting with the state, meeting with law enforcement, trying to save himself. And why he's doing this, why he's meeting with them and telling them this story. You're also going to hear he's writing letters to his family and telling his family, I didn't really do this. I didn't really do this. I'm just going to get the deal. I just want the deal. I want you to know I didn't do it. I'm just saying what I gotta say to get myself home. How much bigger of a motivator could someone have? And it makes you question. If he's saying those things to other people, how do you know the truth? How does the state know the truth before they put him up, right? You know, you're right, 2021, there's video. And I'm going to tell you now, similar clothing doesn't equal the same. All right? Video is going to show what it shows. You're going to be able to watch it, evaluate it, look at it. The crosstown videos and pictures that they show you, look at them, evaluate them. Absolutely. But similar doesn't mean the same. For mass-produced items, you have to ask yourself, is there anything particularly significant or unique about those items that couldn't have been obtained by another person and worn by another person? And look, if that video on its own and the other part of that was enough, why would we need to hear from these other folks? Why would we need to hear from them? They want you to hear from them. They need you to hear from them because there was references of cell phone information. That cell phone information isn't going to be able to pinpoint where they are or where these phones are. That area has all sorts of other locations in it. You're going to hear, you heard that car was wiped. You're going to hear that they did fingerprint analysis on the car. Cornelius Smith's prints are on the car. Another individual named Kristen Gardner on the car. Another gentleman named Trayon Ingram on the car. You know whose fingerprints aren't on the car? Justin Johnson. And if it was wiped and then moved and wiped, as the state suggests, then how are their prints on it? You're going to hear that they did touch DNA, right? So lucky, it's not 1981 anymore. We got touch DNA now. Forensics has come a long way. Crime scene unit went into this car and did several swipes for touch DNA. They don't have anything saying Justin Johnson's DNA. The car that they got, a dude got shot, according to Cornelius Smith. I mean, he got shot in the shoulder. No blood in the car that we're going to hear any forensic analysis about. How is that? These are the things that you as jurors will have to pay particular attention to throughout this case. The shame of it is that people like Govan and Cornelius Smith are going to have an opportunity to come and lie to your face. That's the shame. And they will. The judge instructed you earlier some of the things to be mindful of among credibility. So they appeared particularly honest. And then there becomes one really important. To what degree does what Cornelius is saying differ from what Govan is saying? Pay attention to that. Why is it different? The truth is one thing, right? One thing. And I'm not talking about inconsequential facts. I'm talking about this was a horrible thing that happened to Adolph Thornton. and his family. It wasn't just every day. So, why are they telling different stories? So, we talked about this in Board I or some. The idea of keeping an open mind. I'm going to ask you again to do that. To hold any judgment or consideration on that issue until you've heard everything. And remember, I completely agree. This isn't business this week. This is justice. And as we talked about in Board I, your job is to mete out justice in this case. Absolutely. A life was lost. Absolutely. But as we talked about in Board I, and you all agreed, it's never justice if you convict the wrong person. So I appreciate all of your attention that you're going to provide this week in deciding the fate of Mr. Johnson. Because he didn't kill Adolph Thornton. And he shouldn't be the one that has to take the fall for it. Thank you.
State controversy witness?
The state calls Erica Thornton.
Erica Thornton. Ladies and gentlemen, while we're waiting on this first witness to come in, make sure your phones are turned off, please. Phones turned off. And if anyone feels like that they won't be able to handle emotionally testimony, things they might see, I ask you to leave. Please, remove yourself. There will be no outburst. You swear or affirm to tell the truth? Yes. Have a seat, Dr. Stick.
Good morning.
Good morning.
Could you state and spell your name for the record?
Erica, E-R-I-C-A, Thornton, Thornton.
Thank you. And did you know an individual by the name of Adolph Thornton Jr.?
Yes,
And how did you know him?
it's my brother.
What kind of relationship did you both have?
Sister-brother relationship, we were all pretty close. We had a great relationship, spoke all the time, hung out every chance we could get together. So we had a great relationship.
Okay. And if you were shown a picture of your brother, Mr. Thornton, would you be able to recognize him?
Yes.
And Ms. Thornton, you said, who is that in that picture?
My brother, Adolph.
Okay. Your Honor, I'd request that this photo be entered into evidence and marked as exhibit number 1.
This is a photograph of who has been described as Adolph Thornton Jr. wearing a black cap, turned backwards glasses. We'll mark this as exhibit 1 to this.
No objection.
Thank you.
Thank you, Your Honor. And may I have permission to... Thank you. And Your Honor, may I have permission to publish this to the jury?
Yes.
Go past this. Thank you so much. Okay. Ms. Thornton,
Hold up. Let them look. Ladies and gentlemen, everything that's marked as an exhibit will go back to you when you deliberate. So you'll have opportunities to examine all the evidence.
So, Ms. Thornton, you're familiar with his family, correct?
Yes,
Does he have any children?
yes,
How many children does he have?
he has 2.
Okay. When was the last time you saw your brother?
The last time that I saw my brother was in September, right before Labor Day. So 2 months before he was murdered.
Okay. And you did find out that something had happened to him?
Yes,
Okay. Did you know of any funeral service of Mr. Thornton's?
yes, I planned it.
Okay. And did you attend?
Yes,
Okay. My final question, do you miss your brother?
most definitely.
Okay. Your Honor, at this time, I'd like to read a stipulation of fact into the evidence. It has been signed by both parties and Your Honor.
Any objection?
No objection.
So before you do that, ladies and gentlemen, what she's getting ready to read to you is what she just said is a stipulation between the parties. The parties have chosen to, in order to keep witnesses from having to testify, witnesses from having to testify about certain events and things, the parties can stipulate to those facts. So you might hear a few stipulations throughout, and those will be also entered into evidence, and you'll go back, it will go back with you also. Yes.
The parties in this matter, the state of Tennessee, represented by Paul Hagerman and Iris Williams, and the defendant Justin Johnson, represented by Luke Evans, respectively, have agreed to the following. The victim in this case is Adolph Thornton Jr. He was a living person and is now deceased. Adolph Thornton Jr. was, as you will hear in later testimony, the same person that autopsy 2021-2619 was performed upon. These facts agreed to by the parties and may be accepted as true without the need for a witness or further proof. This is a stipulation made in all homicide cases so that the family members of the victim do not have to view autopsy pictures of the victim. It is so stipulated and approved by the court. And Your Honor, at this time, I request that this stipulation be entered into evidence and marked as the next number exhibit.
No objection.
This is a stipulation of facts dealing with the agreed upon facts of the witness not having to testify as to a autopsy photo signed by all parties. We'll mark this as exhibit 2 for this.
Your Honor, at this time, I'll pass the witness.
No questions.
Thank you, ma'am. Like you said. Are you next witness?
Call Raul Hopkins.
Step up here, sir. You swear or affirm to tell the truth?
Yes.
Yes, sir.
You can face me, you don't have to worry about that microphone, just sort of keep your voice up, okay?
Yes.
Tell us your name.
Blue Hopkins,
Can you spell your first last name?
BLUEHOPKINS.
You go by Blue, is that right, or
Yes,
Mr.
sir.
Blue or something?
Yes, sir.
Is that right?
Real name is Raul, R-A-U-L, Hopkins, H-O-P-K-I-N-S.
Thank you. How old are you?
60.
All right. Do you know Adolph Thornton Jr.?
Yes, sir.
How do you know him?
From the neighborhood, family,
What neighborhood?
Castaic.
And tell the jury where Castelia is.
It's South Memphis. It's north of Dunn.
Is that where, and I'm going to call it, if Adolph Thornton Jr., what did you call him?
Young Dolph.
Young Dolph or Dolph?
Dolph, yes, sir.
Is that where Dolph grew up?
Yes, sir.
Were you Dolph's friend
Friend?
for his whole life?
Yes.
Are you also involved in his business?
Yes, sir.
What was your involvement in his business?
I was his security.
And how many years have you been working his security?
Time 4, 5, 7 years.
Job probably quite a bit of travel,
Yes, sir.
a little bit of stress.
Yes, sir.
Tell me about Dolph's record label. What was the name of it?
Paper Route Empire.
And is that Dolph and other artists?
Yes.
Dolph helped promote those other artists?
Yes, sir.
And Dolph would perform, I assume, concerts and things like this?
Yes, sir.
You were in charge of security for many of these things?
Yes, sir.
For some years, it sounds like.
Yes, sir.
Let me pass you this photograph. You've seen it. Tell me what that is underneath that little placard.
That's the PRE chain.
Okay, and PRE, that Paper Route Empire,
Yes, sir.
his label,
Yes, sir.
and he says a chain, like a necklace or something.
Yes, sir.
Is that Dolph's?
Yes, sir.
You're not around, move that into evidence that states next number exhibit.
Objection.
This is a picture of a chain, emblem for a chain, PRE, with the placard number 64, looks like in a pot. We'll mark that as exhibit number 3.
You familiar with a rival rap label?
Yes, sir.
What was its name?
CMG.
Is that Cocaine Music Group?
I think so, yes, sir.
Does that label have artists and things like it under that umbrella?
Yes, sir.
You familiar with the name Juke or Big Juke?
Yes, sir.
And is that person, to your knowledge, affiliated or part of the leadership of CMG?
To my knowledge, yes, sir.
You familiar with any sort of rivalry between CMG and Dolph?
Yes, sir.
You familiar with sort of the origins of that rivalry?
Yes, sir.
And what is that?
A bus doing shows. We got the soprano shot up. A few other various things. There's a lot of shooting going on.
Okay, well, let me back up, because I think you're talking about incidents that happened,
Yes.
is that right?
Yes.
Okay, let's back up. Do you know, why does CMG have a problem with Dolph at all? You're not familiar with that? You familiar with Dolph ever turning down proposals to sign with artists from CMG?
Yes.
Was it important to Dolph that he did it himself?
Yes, sir.
Did he make public statements like that?
Yes, sir.
Did he make statements like that in his rap songs?
Yes, sir.
In his rap songs, did he call out CMG and those artists?
Yes, sir.
In those rap songs, in fact, did he call out Big Jook?
Yes, sir.
Did he say insulting things about Big Jook?
Yes, sir.
Through the years, has that translated into some violence directed against Dolph?
Yes, sir.
You mentioned 2 incidents. Is that right?
Yes, sir.
To be clear, these are incidents that happened in the past. Is that correct?
Yes, sir.
Mr. Johnson, who's on trial now, was not part of.
No, sir.
Tell me quickly about those two incidents.
1 and 15, we was in Charlotte.
What happened in Charlotte?
We just came to the hotel. We was in the
Sprinter van?
Sprinter van, yes, sir. We was sitting there for about 15, 20 minutes. Ran upstairs. Once we got upstairs, got in the room, 2 more people ran up and said they just shot up by Sprinter.
Bullet holes?
Bullet holes.
A lot of them?
Yes, sir.
Did Dolph end up even rapping about it?
Yes, sir.
An act of CMG violence.
Yes, sir.
What was the other incident?
The other incident happened in California when he actually got shot
Dolph got shot?
in California.
Perpetrators affiliated with CMG?
Yes, sir.
You can see where security would be stressful.
Yes, sir.
Protecting not just your client, but it sounds like your friend.
Yes, sir.
This is just a little piece of paper. Defense counsel's seen this. We just passed this forward, Judge. To the witness. That emblem on that, you familiar with that?
Yes, sir.
And is that CMG?
Yes, sir.
You know, if we just offer that in evidence, the state's next somebody says it.
Objection.
This is the letter CMG with Cocaine Music Group under it. It looks like an emblem. We'll mark this as Exhibit 4.
I could publish these two exhibits, Your Honor.
Okay.
It's exhibit 3 and 4 for the record. Thank you. It's just. I'm publishing the exhibits with the logo of PRE, Paper Route Empire, and CMG, Cocaine Music Group.
Yes, sir.
Can I have Mr. Blue identify some people real quick in the video itself, Your Honor, if we could stop it for a second. I've spoken with defense counsel, and this video will go ahead and admit into evidence. I don't think we need to mark it right now. It's on the flash drive.
We do.
You,
Don't want to mark it right now?
I don't think we need. We can view it if there's questions, and then we can mark it after he testifies, rather than having to load everything back up.
That's fine.
Thank you. I'm gonna watch a little bit of this, okay? Just short. All right, you can stop there. Are you familiar with this car?
Yes, sir.
Whose car is that?
Young Dolph.
It's one of those new Corvettes.
Yes, sir.
I see that it has either a paint job or a wrap or something on it. Is that right?
Yes, sir.
Tell me about that.
It's just, he wrapped a lot of his cars
Okay.
camouflage.
Okay. So it's like a white and blue sort of camouflage pattern.
No, it's more like white and green.
Okay. And that is something he had several of his vehicles in?
Yes, sir.
All right, you stop it there, Iris. Who is that?
That's Young Dolph.
All right. And who is that?
That's his brother.
Is his brother's name Marcus?
Yes, sir.
Do you know Marcus?
Yes, sir.
Has this event had a significant impact on Marcus?
Yes, sir.
Did Marcus sometimes help with Dolph's security?
Yes, sir.
Let's go inside video so we can see it on the inside. Is that the car arriving?
Yes, sir.
Do you know where they were arriving from?
No, sir, I don't.
Do you know if Dolph had been to Makita's before?
Yes, sir.
Had you ever been there with him?
No, sir.
Had you ever even tried the cookies there?
No, sir.
He ever talked to you about the cookies?
Yes, sir.
Is that Dolph?
Yes, sir.
The chain around his neck, is that the PRE chain?
Yes, sir.
The one that we saw in the exhibit?
Yes, sir.
And that's Marcus behind him?
Yes, sir.
Let's go. Happens quick.
Yes, sir.
Last remark is exhibits later on in the trial.
Get it done.
No further
Any
questions?
objection about the marking of the exhibit?
Sorry, Judge.
Any objection to the marking of the exhibit?
No objection.
Any questions, Mr. Evans?
No question.
Thank you, sir.
Good day, Flush, Your Honor.
You may. It's time to take a break. Once again, do not talk about what you heard. You only just heard a small amount of what you're going to hear. So go rest yourself, rest your minds for a little while, leave all of your notes here, and we'll take a state of recess.
All rise. This court stands in recess.